In Brunswick, Georgia today, prosecutors wrapped up day 3 of testimony in the federal hate crimes trial of the 3 white men convicted of murdering Ahmaud Arbery nearly 2 years ago. Federal prosecutors say Travis and Gregory McMichael and William Bryan chased and killed Ahmaud because he was black. Today, a Glenn County patrol officer testified that Travis McMichael's testimony was not true about a string of break-ins in the neighborhood where Ahmaud was killed. The jurors also heard from an agent with the Georgia Bureau of Investigation whose body camera captured William Bryan admitting to chasing Ahmaud in his pickup truck because he, quote, figured he stole something or shot somebody. Now to Minneapolis, where the federal trial of 3 former police officers charged with violating George Floyd's civil rights resumes. Thomas Lane, J. Alexander Keung, and Tou Thao are accused of failing to provide medical aid to Floyd while Derek Chauvin pressed his knee against his neck for more than 9 minutes. Keung and Thao are also charged with failing to intervene. Late this afternoon, Keung's defense rested its case, and Lane's defense team were up next. They called one witness a former Minneapolis police officer. With me to discuss today's testimony are criminal defense attorneys Phil Hamilton and Gerald Griggs. Great to have you both here. Let's start with former officer J. Alexander Keung, who returned to the stand for cross-examination this morning. The prosecutor questioned him at length about George Floyd's condition while he was restrained. Keung said he could hear Floyd's speech getting slower and could also see that at some point Floyd stopped moving. When the prosecution asked Keung if he could see that Floyd was in need of medical attention, Keung said, quote, I never really defined it as a serious medical need. Phil, does this testimony help or hurt Keung's case?
I think the latter part really undercuts the credibility to the extent that he never saw this as a serious medical issue. From a commonsensical standpoint, the entire world could see that there was a serious medical issue going on that ultimately led to Mr. Floyd's death. I think that was the weakest part of his defense. To the extent that he had any strong part, any credible part, it's essentially the a few good men defense that he's been going with, which is that this was my superior. I didn't have that much training. I had to rely on a lot of his experience, his seniority, and certainly I didn't want to undercut him and get in trouble by intervening in any way, right? So I think to start, not very good in terms of King having the defense of I didn't know that this was a medical emergency. Not credible. To the extent that he's going the other route with I was just the rookie that's doing what I'm told. We'll see how that pans out, yo.
Gerald, your thoughts, please.
My thoughts are he should have stayed off the stand. I mean, nothing good came of any of his testimony.
Really?
And I think that it undercut what he's trying to do. I mean, at this point, the whole world saw the man was being choked to death for 9 minutes and 29 seconds. The best you can do is, well, I was just listening to my superiors. I didn't think he was in serious medical distress. The video speaks for itself. So I think his lawyer did him a disservice by not fighting him to stay off the stand.
So that brings an interesting point. I was going to ask you guys later, but I might as well bring it up now. I mean, I felt like if one defendant took the stand, it almost put pressure on the other 2 to take the stand because, I mean, in a juror's mind, you're thinking, well, shoot, we heard from him. I kind of want to hear from the other 2 too, even though they have the right not to. So I feel like they all didn't really have a choice but to take the stand. I think that they should have been better prepped. Phil, your thoughts on that?
You hit the nail on the head. 2 other co-defendants testify, and you're sitting there not testifying. It does put the pressure on you. Now, let's be frank here. Just because the pressure's on you doesn't mean that you have to make the decision to go on the stand and potentially say something, dumb or that, ultimately undercuts your defense and ends up, helping the prosecution prove their burden. That being said, that pressure is there. The optics are there. And that's not lost upon, I think, any of the officers. Moreover, in terms of them wanting to blame Chauvin for all of this and try to deflect the blame, that is a really big leap for all of them. And to the extent that you want the jury to be with you in any way on that, they're certainly going to have to hear from you. You don't get to just be silent the way that you were on the side of the street while Chauvin's knee was on the back of Mr. Floyd's neck. If you're going to go with that defense here, you got to get on the stand and say something. And I think that the 3 of them recognize that even if ultimately they didn't do themselves the full service of where they may want to go with it, I think they had to go.
Gerald, speaking of dumb, I thought Tao probably handled himself better, so to speak, than King did, because King also said that it was necessary to keep Floyd pinned to the ground despite him being unconscious because he could come back and fight again. That's a quote. To save his life, we needed to hold him down for medical personnel. But he was unconscious, but yet he could come back and fight. He's handcuffed in a prone position with 3 officers holding him down, one at the neck, legs, and I think back. And to save his life, we needed to hold him down for medical personnel. He died.
Again, this is one of the reasons why you don't take the stand. I mean, you use the super Negro defense, and that never ever works. And so, my concern here is that even though you really don't have to prove anything, once you get on the stand, all eyes shift from the prosecution's case to whatever you say. And if they don't find you credible, they're going to convict you. In this particular case, all of them should have stayed off the stand. And if you're going to be pointing the finger at another defendant, even though they're not there, usually the prosecution makes hay on that because look, they're pointing the finger at each other. Listen, you don't have to figure out which one's more guilty. They're all guilty. And so I just think that it was a grave tactical mistake by their defense attorneys. I think it was better to just say that the prosecution can't prove their case beyond a reasonable doubt and focus on taking apart the prosecution's case.
Let's talk about Thomas Lane, because after King's attorney rested, his defense attorney called a former Minneapolis police officer who spent 25 years on the force, and he talked about the training the officers go through. He testified that the officer with the most seniority obviously was in charge, of dealing with a hostile situation. In this case, it was Derek Chauvin. The defense attorneys, again, have been trying to shift the blame to the person that has already been convicted, right? It's the easiest thing to do. And they keep hammering the point that Chauvin was the one in charge, and what happened to Floyd was his fault, his doing. Phil, I know that you said that this strategy wouldn't work. However, when you have, Tao, for example, he's been on the force for 8 years. And then you have the other 2, his co-defendants. We're talking about days, right? There's a huge difference there. And when you're talking about the intimidation factor, when you're talking about how they can be terminated at any point in time because of a seniority position that Chauvin was in, that they were taught and trained to listen to Chauvin. When you're a juror, that can actually be kind of persuasive. I mean, it's easy for us to say, well, you should have done X, Y, and Z, but in the moment, it's not that hard. It's not that easy.
I mean, to be clear, with respect to that, defense, as I labeled a few good men defense, as I noted, we'll see ultimately how it comes out. Because I think, look, as a trial attorney, particularly from the defense standpoint, as has been noted, the criminal defense side never has the burden to prove the case. That's always on the government. That being said, when you're going to trial, even if you don't take the stand, but certainly when you do as the defense with everything you do have to thread through a story of innocence throughout the course of whatever you're doing, cross-examination, closing arguments, opening arguments. You have to thread a story of innocence, and you have to have a hook that the jurors can morally grab onto that gives them the leeway and license to acquit your client, sometimes of the most heinous events. And so I think what's happening here is that they're trying to humanize, as you noted, the fact that, okay, you got a couple of rookies here, they're on probation, at the force, they don't have a voice within the force. If they do stop Chauvin, and let's presume that Mr. Floyd doesn't die, then they're going to be in trouble within the force. It's going to be that blue wall against them. They're not going to get help when they need calls. They're basically trying to say that all of those kinds of things were going through King's head more so than actually attending to Mr. Floyd and seeing if everything was okay with him. And to the extent that you can get a juror or two to latch on to that, you have to remember they don't need 12. They only need 1 in terms of being able to try to get a mistrial or get their clients up from out under this indictment. So in that respect, we will see ultimately how it works. I don't think it's necessarily the strongest defense because they still have a duty to intervene where there's unreasonable force. But when you're in an uphill battle the way that they are, you got to go with what you can go with. And to the extent that they're saying that they were rookies, that were just under the pressure, that's what we see them doing. We'll see how it works out.
Gerald, this duty to intervene, Lane wasn't charged with that, right? Because he tried to, on 2 occasions, I believe he wasn't charged with that, but he, on 2 occasions, tried to suggest to Derek Chauvin, should we not, flip George Floyd on his side, to which, Derek Chauvin said no. Will that, because Lane is going to be taking the stand and he's going to reiterate that point, does that hurt the other 2 who are making the excuse that, oh my God, Derek Chauvin is our senior officer, our training officer, he's got way more experience, we trust him, but you have this officer who's just days in on the job making a suggestion. Does that hurt their argument?
Absolutely, it hurts their argument because you can see some amount of humanity and some amount of care where he's saying, hey, this guy seems like he needs some help. Let me see if I can help him. And I can't help him. At least he can make that argument, which cuts against the other 2. So I think that he's in a better position of the really bad positions, but at least he was attempting to do the humane thing and also do what he was trained to actually do. That's intervene when you see somebody that's in distress. So I think he's in a better position, and it will cut against the other individuals, the co-defendants. So this is the problem when you have multiple co-defendants. You got multiple co-defendants taking a stand. Sometimes their defense can sink the other 2.
Phil, reporters inside the courtroom say that at times the judge appeared to be irritated by some of the questions from the prosecutor. Obviously, this is a federal trial. No cameras are allowed, and I wish we knew why exactly. But, we also heard that the prosecution, was visibly frustrated yesterday at all of the sustained objections by defense counsel. So, when you have a prosecutor who's cross-examining a defendant, that's a golden opportunity, right? That rarely happens. So when you have that opportunity, you need to take advantage. But you also have to keep in mind that the prosecutor is cross-examining officers, right? At least for Thao, who's probably testified a number of times and knows how to handle themselves. How should the prosecution proceed in their cross-examination to make it more effective?
Look, I think number one, I mean, as you know, there's no cameras there. So, we can't necessarily see the tone, demeanor, and even just from a foundation standpoint, how they're asking their questions. I mean, general trial one-on-one advice is ask tight, leading questions. To the extent that you start asking compound questions, to the extent that you start taking the jurors places where, from an evidentiary standpoint, they wouldn't have the personal knowledge to be able to answer, you're going to get a lot of those objections sustained. And let's just say this: defense attorneys typically cross examine a lot more than prosecutors do, right? Let's just be frank. A lot of times, defendants don't testify, they don't put on cases. Criminal defense attorneys are more accustomed to the way in which you have to cross examine to avoid those objections. I've seen it at times where you have prosecutors who just aren't accustomed to cross examining as much. They get themselves caught up evidentiarily in asking the wrong question, not providing the right foundation. And yeah, the judges will get annoyed at that because at the end of the day, there are rules that you have to follow within the court. The judge is trying to protect their record, trying to make sure that if these defendants are convicted, that there's no way that they can come back on appeal because, of some error in the way in which prosecutors were asking questions and the judge wasn't sustaining objections if they were wrong, right? So I think in many respects, if I'm them, I'm going back to evidence 101 in law school and just asking tight questions to the point and making sure I'm following the rules of evidence so that I'm not dealing with the judge's objections and irritation.
Phil Hamilton, Gerald Griggs, always appreciative of your expertise. Thank you so much.